Thank you all for joining the webinar, Achieving TCPA Compliance in Your Contact Center. I'm Shelby Ferris, the Marketing Program Manager at Connect First, and I'll be your moderator for today. This webinar is being recorded, and it will be shared to all registrants later this week via email for your viewing convenience. We will also be hosting an additional webinar in the Connect First Compliance webinar series, Achieving HIPAA Compliance in Your Contact Center. We will be doing this with PACE and Compliance Point on April 8th. You can register for this webinar online at connectfirst.com/resources/webinars. I'll also be sending out this link in an email later this week with a recording of the webinar. We are also excited to announce our March 25th webinar with Donna Fluss of DMG Consulting. Donna will be presenting findings from a recent survey where she asked top executives, what is your top enterprise servicing goal for 2015? We will be answering attendee questions at the end of the webinar, so if you have any questions, feel free to send them in any of the three following ways. You can either send them in through the Q&A feature on the GoToWebinar side panel. You can email your question to marketing@connectfirst.com, or you can tweet your question to @ConnectFirstInc. Michelle Schuster wasn't able to make it to the webinar today, but she was luckily able to give us one of the firm's partners, Nick Whistler, to fill in for her today. We also have compliance experts Ryan Thurman from Contact Center Compliance and Jeff Minna from Connect First. Nick Whistler is a partner at the law firm McMurray, Peterson & Schuster. Nick assists clients in highly regulated industries comply with federal and state consumer protection and privacy laws and regulations, including the TCPA. Nick is a certified information privacy professional and currently serves as co-author of PACE Regulatory Guide. Ryan Thurman is the Sales and Marketing Director with Contact Center Compliance with over 10 years of experience in the contact center industry. Ryan is recognized as a compliance industry expert with a focus on state and federal marketing and privacy regulations, including FCC, FTC, state and global compliance regulations. He also serves as the regulatory chair of the West Coast chapter of PACE and the International Subcommittee Chair of the Compliance Officers Forum at PACE. Jeff Minna leads the company's strategic direction and is also the primary architect of the Connect First platform. Jeff has over 15 years of experience in the cloud telecommunications space. He is responsible for driving the focus of combining world-class technology with unmatched customer support into every aspect and is extremely passionate about creating strong and mutually beneficial business relationships. We're going to start this webinar out with a real quick poll. When we were going through the registration forms for this webinar, over 80% of you listed compliance as your primary pain point in the industry, and several of you actually stated that your company was currently in a TCPA lawsuit. So this sparked our interest, and first we want to ask, is the company you work for 100% TCPA compliant? Okay, it looks like we've got about 70% of the votes in. If the rest of you want to vote real quick, we can see the results. Okay, so pretty interesting results. A lot of you are pretty much TCPA compliant. Some of you said no, and a pretty decent amount of you said that you weren't sure. With most of the compliance violations due to uncertainty about TCPA regulations, and with most of your primary concern being compliance, you guys are on the right webinar. Nick is going to take over, and he's going to clear up some of this uncertainty. He's going to be talking about TCPA regulations and some of the most recent TCPA cases.
All right, thanks, Shelby. So for those of you that have attended a PACE webinar or the Connect First webinar that we did last fall, there's going to be a little bit of repeat here. I think it's just kind of important to lay the groundwork of what the requirements are, and then we can dive into some of the more recent developments and how those impact the underlying requirements. So just bear with us, but I will go through relatively quickly just to save a lot of time for Q&A, and I think that's going to be one of the main values taken away from this, is the ability to ask specific questions that we didn't necessarily include in our slides. So with that as kind of a background, as it sounds like most of you are either very much concerned about TCPA compliance or had been involved in some type of TCPA lawsuit. That's nothing but to be expected, I guess, in the current landscape of TCPA litigation that we're dealing with right now. This chart here is just a very tip of the iceberg type of chart that outlines some of the more recent settlements. Most of these were from either 2015. I think there's a few actually in the last month or two of 2014. So you can see that the dollar amounts range from a couple $1 million up to $75 million here. But the other interesting thing from that chart is to note that the TCPA lawsuits are actually impacting a wide range of industries. Financial services has been hit pretty hard because of the debt collection issues, but really it's across the board. It's anybody that's contacting consumers via phone or text or even fax for that matter. So huge impact, and what I'd like to do is just kind of go through what the rules are, and then we can talk about what the more recent developments have been. So the general rule regarding calls to cell phones, which has been the biggest issue recently, is that you can't use an automatic telephone dialing system, which is referred to often as an ATDS, or a pre-recorded message to call a cell phone without consent. And as of October of 2013, there's now two types of consent. For a non-telemarketing call, you need prior express consent. And for a marketing or advertising call, you need prior express written consent. So we'll talk a little bit about what each of those mean at a high level and where the courts have been coming down on those. We're also going to kind of dive into what is an ATDS, because I think that's kind of one of the more pressing issues right now for a lot of folks. So before I get into that, though, as you see at the bottom of the slide, I just wanted to kind of throw out a couple of comments here. Number one, I think there's a pretty big misunderstanding in the industry right now that business-to-business calls are not subject to the TCPA. And while there are certain provisions of the TCPA, like the do not call laws, that do not apply to B2B calls, there are a few others that actually do apply to B2B calls, and most notably, and what we're going to be talking about today, are calls to cell phones. So if you're making a business-to-business call, but it's to a cell phone, that is subject to the TCPA restrictions. So you will want to pay attention and think about how these developments impact your campaigns. Lastly, just remember that if you are calling a cell phone and you're not using an ATDS or you're not using a pre-recorded message, then you do not need consent under the TCPA. You can make those calls without consent, subject, of course, to do not call laws and to any state laws that might apply as well. So with that, going to the first question, which is, what is an automatic telephone dialing system? The statute defines it as equipment with the capacity to store or produce numbers to be called using a random or sequential number generator and to dial such numbers. Pretty narrow definition. The word capacity is problematic, and we're going to talk about that quite a bit here, but it's pretty narrow in terms of its scope. The problem, though, is that the FCC a few different times has expanded that definition to basically include any equipment that has the capacity to dial without human intervention. And specifically, they were talking about predictive dialers, but it's been applied to equipment used to send texts and for a few other types of equipment. But anything with the capacity to dial without human intervention, according to the FCC, is an ATDS. The courts, they've been addressing it in a few different contexts, so I've kind of broken these down into three main issues that are being addressed by the court. Shelby, can you go ahead and advance to the next slide for me, please? Thanks. The first is, what does capacity mean? So when we talked about the word capacity, there's been a lot of disagreement about what does it mean for equipment to have a certain type of capacity. The second question is, okay, well, once we resolve the issue of what does capacity mean, what are we looking at? The capacity to do what? Is it the statutory definition, or it's random and sequential number generator, or are we talking about the capacity to dial without human intervention under the FCC standard? And the third is, if it is the FCC standard, what is human intervention? So I'm just going to go through some of the case law and break it down by those three different categories, starting with what is capacity. The majority of courts have held that the relevant inquiry is the equipment's present capacity. And what I mean by that is, what can the system do as it's currently configured or currently constructed? Not just how you're actually using it, but all the different types of modes that are on that system would all fall within its present capacity. But what would not fall within that is the ability to dial if it was recoded or somehow modified in some way. So the first court to really address that was that Hunt case from Alabama in 2013. Since then, there's been several more, which are listed here. On the next slide, there's a couple other ones. The Marks case from last year, which I think we talked quite a bit about during the last webinar, and then a more recent case, this Glosser case from the Northern District of California. I want to talk about both of those a little bit more, but before I do that, I actually want to jump ahead to the minority opinion on the next slide to talk about the Sherman case so that we can circle back and see how these two other cases kind of mesh with the Sherman case. So Sherman is basically the only case out there that does not use a present capacity standard. It adopted a future capacity standard. So that court said it's not just how the equipment is being used, it's not just how it could be used right now, but if you could modify it in such a way that it did have the capacities to be an ATDS, then it meets the definition and it's subject to the consent requirements. The reason that it held that is because it looked at two Ninth Circuit opinions. So Ninth Circuit is the appeals court that's above the Southern District of California. And it looked at Satterfield and Meyer and said those cases stand for the proposition that future capacity is relevant. I've been saying all along, most of the other people in this industry have been saying all along, that that interpretation of those rulings was problematic, that there really wasn't anything in either of those cases that really supported that interpretation. And as it turns out, and Shelby, if you don't mind going back to the previous slide, some courts are starting to agree with what our initial thoughts were. Marks, which is within the same district as the Southern District of California, it's a different judge, but relied on a present capacity standard rather than the future capacity standard that was adopted in Sherman. So, when a issue gets decided in a certain district court, future decisions in that court are supposed to be bound by that. But in this particular case, they did not defer to Sherman. They kind of went out on their own. They cited Satterfield and pointed out that there was nothing in there to support the Sherman court's opinion. So that's a pretty good case. Most recently, this Glosser case kind of did the same thing. It said there's nothing in either of those opinions that requires a future capacity standard. We think that's a ridiculous standard. We're going to go ahead and adopt what most courts are doing, which is a present capacity standard. So both of these came after that Sherman case. Both are very good for industry. Glosser probably doesn't get you all the way there in terms of being able to use a predictive dialer, but it does provide some much needed guidance on the capacity issue. So a good development overall. And as a whole, I would just say I feel very confident with the present capacity standard. You just have this one outlier case. It's the only one. So I feel pretty confident in relying on that for purposes of proactive compliance planning. So the next question after we talk about what does capacity mean is, what are we talking about? The capacity to do what? And here's just a long list of cases that have deferred to the FCC and said that the relevant inquiry is the capacity to dial without human intervention. So they are not looking at it as narrow as the statutory definition. They're not looking at, is it random or sequential number generation? They're really looking at, did you dial the numbers automatically? Was there human intervention involved with those calls? There are a couple cases that have said, no, we don't think that the FCC had the authority to issue that interpretation. And on the next slide, you'll see the Marks case that we talked about already, and then there's the Dominguez case, both from last year, specifically rejected the FCC's interpretation. So there are a couple courts out there that have really limited this to the statutory definition. What I would say is, if you're in a lawsuit, these are the cases that you're going to want to point to support a narrow interpretation of ATDS. But if you're trying to be proactive and you're trying to think about what can I do to not get sued, what can I do to keep my company out of trouble, you really don't want to be relying on this standard right now unless we get some type of clarification from the FCC. You really need to default to the majority position that we talked about, which is any equipment with the capacity to dial without human intervention, that's an ATDS. So treating predictive dialers like an ATDS, even despite a couple cases that you might be able to point to. The next issue is, okay, so if we're using human intervention as the applicable standard, well, what does that mean? There have been a few courts that have started to address this a little bit more in the last year or so. Most importantly, I would say we have a couple opinions that support a one-touch dialing. So this does help a little bit in that we don't have to dial all 10 digits of the phone number. We can use kind of a preview method of dialing. I would just caution that you'd want to make sure that the equipment that you're using for the preview dialing can only dial that way. It can't dial predictively. And you even have some guidance from the FCC dating back to '92 that also supports that type of dialing. So no courts have really come out with an interpretation that's contrary to one-touch dialing. So I feel pretty comfortable with that as well. The other thing, though, is that once the human intervention standard was being adopted by a bunch of these courts, defense attorneys got a little bit creative, and they said, okay, well, there is human intervention involved. I had to come up with the list. I had to load the dialer. I had to do all these different things. And the courts have largely rejected that argument. They've said it's the human intervention must occur at the time the call is placed. So talking about actually doing something to trigger the call, not just loading a list in terms of something that would take it outside the scope of an ATDS. Most recently, there's been a few courts that have addressed human intervention in the context of text messages. So those are kind of outlined here on the next slide. The issue here is been equipment that sends some type of automated response message. So in the Yahoo case, it was a welcome message. Somebody would sign up for the service, and by signing up for it, would send them an automated welcome message. In the two cases this year from the Northern District of California, they involved group text. So I start a group text. I sign up 8 of my friends, and by signing them up and initiating that group text, the system would then send messages to everybody in that group on how to opt out and how the group text is going to work. And what the courts in those cases said was that the user, by signing up for that service, by establishing that group, that was the human intervention that triggered the text. So it wasn't even human intervention on the business side. It was actually on the consumer side, and they held that to be sufficient. Unfortunately, the Northern District of Illinois in that Johnson v. Yahoo case, they kind of analyzed that same argument. They thought that it was reasonable, I think is what the terminology was used in the opinion, but they said that that was something that a jury would have to decide. So that one actually, if it doesn't get settled prior to that, we'll go to a jury to decide whether that's human intervention or not. So kind of miscellaneous for those of you that are doing text campaigns, this may or may not be relevant, but I think it's interesting just to see how the courts are interpreting, what is human intervention, and the fact that at least one court has expanded it to some type of action on the consumer's part, I think is at least somewhat promising. So let's say that we are using an ATDS. Let's say we're using some type of predictive dialer or other auto dialer, and we're going to make a call to a cell phone. If it's a non-telemarketing call, we need to meet that prior express consent standard that we talked about at the beginning. That term is not defined under the regs or the TCPA. But way back when the FCC adopted the rules in the early 90s, and a few times since then they've kind of affirmed this position, but they said that a consumer that provides you with his or her phone number as a contact number and doesn't place any limitations on that, doesn't tell you not to use that number to contact them, they're providing consent for a non-marketing call. That's the standard that companies have been relying upon for 20 years to contact cell phones up until the written consent standards were adopted a couple of years ago for marketing calls. So the fact that somebody is giving you a number does give you consent to call them for a non-telemarketing call. Virtually every court that's addressed this issue has deferred to the FCC. There was the Mays case that's listed on the next slide that a while back kind of said that the FCC ruling was invalid. Fortunately, though, that was overturned, I think, last year by the 11th Circuit. So at this point in time, the overwhelming majority of case law supports the position that somebody provides consent by providing you their phone number. The only kind of caveat I'm going to throw on that relates to this Walgreens case and the FCC brief that's listed on the slide, which is that you need to be very careful about what is said to the consumer, what's presented to them of why you're getting that phone number. In these situations, the consumer's told one thing. For example, in the Walgreens case, they were told it was just going to be used to differentiate one consumer from another. There was no mention of reaching out to them, making calls to them, etc. So when those calls were made, they said it was outside the scope of the consent that was provided. So you need to be very careful that you're not limiting why you're getting a phone number, what it's going to be used for. You should just get it for a contact number. Otherwise, you may run into some issues. As far as written consent goes, so this is the standard that would apply to any telemarketing call to a cell phone. There's a few different standards that we need to meet here. I'm going to go through these pretty quickly because I think we've covered this quite a bit in the past. It's got to be a written agreement. It needs to have a signature, but that can be an electronic signature. So you can get it online. You can get a recorded verbal authorization. Those would all meet the definition of an electronic signature as long as they're set up properly. You need to get consent for a specific seller. You can't just get consent for your marketing partners to call somebody, so it needs to be very specific. The consumer's got to take some type of an affirmative action. We really need to indicate their consent. You can't just rely on some type of inaction on their part. And I think what's most problematic for most companies is this are the mandatory disclosures outlined under the rule. So you would think that it'd be enough to say, hey, yes, please call me. That would be written consent. The problem, though, is that the definition requires specific disclosures to be made. Those are listed here. It's got to be consent to use an ATDS, not just consent to call them. And you have to disclose that consent's not required as a condition of purchase. So those aren't very marketing friendly. We've worked quite a bit with clients in terms of trying to set up language that's, I guess, the least intrusive, but that's always a challenging thing to do, and we've worked back and forth to try to get it to something that marketing can live with, but we feel is going to be compliant as well. So be very careful on what you're doing to get written consent under these new rules. And the last thing is you need to keep records. If you can't prove consent, it's no good, and you need to keep it for the entire duration of the time that you could be called, or I'm sorry, that you could be sued. So we would recommend keeping it for at least 5 years from the date of the last call you're making to that consumer under the consent exemption. So real quickly, a couple of the issues that I wanted to talk about that have been popping up a lot recently, first being the reassigned numbers. So this is an issue for companies that have consent to call a consumer, whether it's the lower level of consent or the written consent. But what happens is the number gets reassigned to a new consumer who has not provided any type of consent for that call. And because you need the consent of the quote-unquote called party, companies are getting sued. And the courts, unfortunately, are saying that called party really means the current subscriber. It's not sufficient to have consent from the person that used to have that number. You need consent of the person that actually received that call. So that creates a compliance challenge for all companies because there's no one definitive list of here are all the numbers that have been reassigned. There are some resources that you can use to try to kind of make that determination and try to stay on top of that, but there is no one FCC-sanctioned list like the Do Not Call list that you can use to insulate yourself entirely from liability. So it's a little bit of a problem. There are a bunch of pending petitions before the FCC on this issue. We're trying to get clarification from them, some type of safe harbor, some type of clarification that the consent applies until you are put on notice that that number no longer belongs to the old subscriber. So unless we get clarification from the FCC, though, I think that it's an issue that is going to remain for companies. The next issue relates to what I call the called charge provision. And this is basically just to say that the rules for calls to cell phones actually apply to not only calls to cell phones, but also for any call to a number for which the party is charged. And the issue came up, I think, a couple of years ago in this Lynn case where a call was made to a VoIP subscriber, and that particular subscriber was charged for all incoming calls, and so he sued under the TCPA. Well, both the district court and then last year the circuit court held that because he was charged, the TCPA's consent requirements applied and that those calls were unlawful because they didn't have the requisite level of consent. This is obviously a problem because, number one, and I think Ryan can probably talk about this a little bit more later, but I think there may be some services that you can try to identify VoIP services, but even if you can identify those, there's no way to identify whether that person is charged for incoming calls. I mean, you have no idea how their plan is set up. So this is another one of those compliance nightmares and something to think about in terms of whether you're using an ATDS to make calls to these numbers. So that's really all I have in terms of what's going on. I mean, the most recent developments are those ATDS cases and a few other things such as the FCC denied the Second Circuit's request to provide clarity on that wrong number issue. So they had asked the FCC to provide clarity for the case that was presented to them, and the FCC said, well, we're going to address that as part of these petitions. We don't think right now is the appropriate time. So I think the courts are even struggling with this, and it really is going to be vital for the FCC to provide some type of clarification on that and many other issues, including the ATDS issue. So with all that being said, I think that the takeaways here are, number one, and I say this every webinar or presentation that we give, you need to make sure that you have good policies and procedures in place for all the very high-risk areas. Right now, calls to cell phones is at the very top of that list. You need to make sure that you're buttoned up. You understand all the types of calls being made, what type of consent you have, what records are being kept, all of those things. Secondly, you need to conduct recurring audits of both your internal operations and also on the vendors and lead generators with which you do business. We didn't really get into this today. It's a topic that could be an entire webinar in of itself, but there is liability for calls made by third parties on your behalf, so you need to be cognizant of that. We've talked a lot about the ensuring proper consent and making sure that you're getting the right level of consent. The one thing I'll add here, though, is that we're moving to permission-based marketing, whether we like it or not. More and more laws are coming out to say that you need consent to contact somebody. To the extent that you possibly can, get ahead of the curve by getting written consent for calls, for emails, for whatever else it might be. Even if it's not mandated right now, the extent that you can do that, you know, I think you'll be well served and ahead of the game if you can do that. And finally, and I'm going to reiterate this, something I mentioned before, the TCPA cell phone rules do apply to B2B calls, so you need to make sure that you are applying the correct set of rules there. You may want to, and so can you go ahead and move to the next slide for me, please? You might want to consider moving to a non-ATDS dialing solution. So for telemarketing calls, if you don't have written consent, that's basically your option. You either do that or you don't call cell phones. But even for non-telemarketing calls where you think you might have consent, with the reassigned number issue, with the VoIP issue, you might really consider, even to the extent that you can do it from a business perspective, you may consider moving to a non-ATDS dialing solution for those types of calls as well. And lastly, we didn't really talk a lot about state laws. Just know that there are a handful of states that restrict calls to cell phones, even if you're not using an ATDS. There's a handful of others that talk about text messages as well, but make sure that even if you're complying with the TCPA, that you're looking at these state laws as well, because there is some exposure under those state laws. So with that, I'm done, and I think we're going to kind of open it up for the rest of the panel to weigh in.
Thank you, Nick. That was a lot of great information. Yep, now we're going to switch gears to the panel portion of the webinar and get some of these TCPA questions answered. Nick, it seems like it's really important to have vendors and partners that are TCPA compliant. Are there a lot of vendors in the market that do have a compliant solution?
Yeah, so I mean, I think there's a couple of different things here, depending on how broadly you're thinking about vendors. So, if we're talking about a telemarketing vendor used by a seller, I would say that if I'm the seller and I'm looking at different vendors, I'm asking them to provide documentation of what type of equipment they're using to call cell phones, and making sure that I feel comfortable it's not an ATDS unless I have written consent or the proper level of consent for that call. If we're talking about vendors in terms of like IT vendors, telephony vendors, et cetera, I do think that there are some solutions out there where, as a matter of necessity, companies are turning to these, businesses are turning to these vendors to provide them with a solution that's not an ATDS. And we've been asked by several clients to review their vendors, or maybe they put something together internally or whatever, but to review their dialer to make sure it meets the TCPA standards and that it doesn't fall within the definition of an ATDS. So I do think there's a bunch of things out there. I just think that people need to do some research and find what's best for them.
Thanks, Nick. Jeff, do you have anything to add to that?
So I think that it's difficult to, when you're talking about technology vendors, because that's the point of view where I'm going to speak from, sometimes it's difficult to tell whether the systems that are being claimed to be non-ATDS are actually not ATDS systems. So from a technology vendor and partner standpoint, having third-party attestations or third-party opinions on the technology should make you sleep a lot better at night. There's a lot of vendors out there claiming to be non-ATDS, but if they were to be ripped apart during a technical deposition, that claim may fall down.
Thanks. Ryan, do you have anything to add?
Yeah, actually I do. I think the other case that we didn't talk about much, but I think it has a big bearing, especially positive in terms of Jeff's direction, is the CallFire case, where they found that the CallFire is a dialer company, basically. They found they were able to defend themselves, I believe, by the fact that they were determined to be a common carrier. And this was very recent, like within the last week or so. And so I think overall, yeah, they had been dealing with compliance issues, and that's a good decision in terms of where he sits legally, but just in general in terms of the industry. But I think it just really, you have to look at the TCPA is really being the biggest problem that's out there, and the professional litigators that are making a living targeting call centers.
Thanks. And Ryan, why do you think TCPA compliance is becoming a bigger deal and there's been so many threats and fines in the past, more so than in the past?
Well, I think a combination of things. One, they changed the law and made it more restrictive. And then the other fact is they made it very easy for companies to become targets. And it's expensive to go out there and make the argument that what you're using is or isn't an auto dialer. And so the professional attorneys know that, and they've been very successful. And so you see people that have a substantial amount of litigation coming out of their offices. There's one good example is the Lemberg Law Group. They filed like 508 lawsuits in 2014, I think 28 last month alone. And they've even got an application where you can go out there as a consumer and file complaints to them through your Android phone. Stuff like that is causing a lot more, making it a lot easier for them to get the information and file suits against marketers. So the door's kind of wide open. And the FCC, like Nick said, basically also has been real reluctant to clarify the whole issue. A lot of cases seem like they're just deferring to the FCC, so you get a lot of uncertainty behind everything. It's kind of a perfect storm, and majority of contact centers, I mean, their data is comprised of a lot of wireless numbers, or the numbers that they do want to call. So a lot of companies, too, I've heard, have started to take down the use of the word dialer on their websites and things like that, because that's been used in suits where they'll go out and they'll say, well, it says on your website you're using a dialer. So
yeah, and if I may interject here, Ryan, I would echo everything that you said. I mean, it really is a perfect storm, and the thing I would say is that it's kind of a copycat business. So they see these other law firms, these plaintiffs' attorneys firms making huge amounts of money on these class action settlements, and so they want a piece of the action as well. So they're now soliciting. The Lemberg law firm is a good example. They have that app where they're soliciting consumers to contact them, and it allows them to file suits more easily. But now people advertising on TV, radio, et cetera, the websites, asking, have you received calls on your cell phones? You might be entitled to compensation, those types of things. So it really is just a perfect storm of lack of clarity and a environment that incentivizes these class action attorneys to really be very aggressive in terms of their lawsuits.
Nick, are only large companies target for these TCPA fines?
So I do think that if I'm a plaintiff's attorney, I am more likely to be enticed to bring suit against a large company, but it's not exclusively the large companies. I mean, we're seeing companies of all sizes being sued. And the other thing is, even oftentimes when it is a large company, there's a vendor that gets brought in. There's other types of call centers that somehow played some role in that are brought in as well. So I would strongly advise not relying on the fact that you may not be the biggest of companies as your justification for not being compliant.
Okay, Ryan, do you have anything to add to that?
Yeah, I think the main thing is you want to look at some of these fringe areas too, like Nick mentioned the VoIP issue, because that's a tricky one. We can, for example, identify VoIP numbers, but VoIP numbers really are self-reported by carriers sometimes when they're purchasing them, and so there's not a nationwide database of VoIP numbers, but there is a small percentage of them that have this aspect where they're not your typical number where you don't get charged, and so you're charged per some cost increment, and so you really have to make a decision of how you're going to handle compliance risk. Are you going to call VoIP numbers and just wait until they tell you they're getting charged for these calls, or are you going to want to scrub it out ahead of time and treat them like wireless? That is a big impact. VoIP is a fairly large percentage of numbers, so I mean, I think there's somewhere between 40 to 60 million different combinations. So that's one area. I think looking at your specifically like your internal call list, and even doing like we have a litigator scrub kind of protector scrub solution now. Make sure you can track these people when they're filing multiple lawsuits. So there's ways to kind of refine your dialing strategies or marketing to try to avoid some of these potential areas, and especially the business-to-business one. That's a huge trap because I have actually several clients that have been sued in that area because the plaintiff's attorneys seem to see vulnerability because they're not normally thinking of themselves as a company needs to comply with scrubbing and telemarketing type rules. So a lot of times they're exposed by running fairly large-scale dialing schemes. So that's one to definitely look into as well.
So what should a company do if they don't have the resources necessary at the moment to become TCPA compliant? Jeff, do you want to start this one?
Sure. I mean, the answer there is pretty simple. Find them. I don't think anybody can afford in this environment to ignore it or kick the problem down the road. There's a lot of people out there that can assist, and we've had some customers that didn't have the resources to really dive in and understand TCPA compliance, and a couple of them opted to just stop outbound dialing until they got a handle on it. I think in terms of the penalties, you just can't afford not to.
Nick, do you have anything to add to that? Maybe if a company is smaller and doesn't have the money to look into TCPA compliance, where should they go? What should they do?
Yeah, I mean, I would echo Jeff's sentiment. I mean, I just don't see how you can afford not to be compliant. The penalties for a private right of action is up to $1,500 per call, and the way that people are fishing for consumers these days, I just don't see how you can make outbound calls to cell phones and not be compliant. Now, keep in mind that cell phones is just one component of TCPA compliance, right? I mean, we've got to follow do not call laws and meet a bunch of other requirements, but cell phones is just one of the trickiest issues right now and one of the biggest areas of risk. So when we talk about TCPA compliance, I would say focus on the high-risk areas first. Maybe you don't have the resources to devote to all of the other smaller, I don't want to say smaller, but less risky items, things like calling time restrictions or other kind of technical things. But if you're not compliant with do not call and rules for calls to cell phones, that's just a huge problem, and I don't see that being a business model that's going to get you very far.
Thank you. What are the compliance risks for business-to-business campaigns with TCPA? Brian, do you want to answer this one?
I would just, the biggest risk is assuming that you don't have wireless numbers in your list, that all your business data is comprised of business phone numbers. You're going to have cell phone numbers in there, and assuming that your dialer is safe for that type of campaign, I think is the biggest risk, and just being a kind of a target for another angle which comes into play in business to business, which is B2B call campaigns that are using robocalls. There's a large percentage of those campaigns that still use that technology, which has a even higher risk, not just with the TCPA, but state rules. But on both ends, that's where I see there's a lot of potential risk. The combination of robocalls and data that has cell phone numbers in it, and then you also have to think about what you want to do with do not call with B2B lists, because there's been a lot of people that have found that it's more effective just to even use that suppression as well. meaning you got a B2B campaign, still take out do not call just because of the amount of businesses that have ended up on the national DNC list.
Nick, do you have anything to add?
Yeah, so that do not call one is an interesting one, and I definitely have seen a few issues where calls have been made to a number that maybe is used as both a residential number and a business number, and there's been a lack of clarity in that area as well at the federal level of whether that type of call was subject to do not call laws. There was a recent case, I think it was late last year, that came out where they finally addressed it. I mean, it's just one court. Other courts don't have to defer to this, but it was one court, and it said, the plaintiff was saying, this number is listed on my bill as a residential number, therefore it's a residential number, it's subject to the do not call laws. The defendant was saying, okay, that's great, but you held it out as your law firm number. You're advertising in directories, it was on your letterhead. You were holding it out as your business number. We were calling you regarding business services, and the court actually agreed with the defendant in that case and said that although it might be relevant in certain situations how the number is classified by the carrier, if you're holding it out as a business number, you lose TCPA protection for purposes of a do not call law. Now again, that's the do not call portion. That's not the cell phone restrictions that we've been talking about for a decent portion of this call, but I do think that the DNC issue is there, and I would just reiterate the cell phone issue again. There are some other requirements under the TCPA, like call abandonment rules actually apply to B2B calls, which I think some people find surprising. So you just want to be careful that you're applying the correct set of rules, and then the state-by-state rules may apply as well. Just, you need to do a thorough analysis of which of those laws apply and which don't.
Okay, so we had someone state, we use a third-party BPO. Does the BPO need to be compliant in order for us not to get in trouble? Jeff, do you want to answer that one?
Sure. Yeah, I mean, everybody has responsibility in the chain. You can't hire a BPO to make calls on your behalf and feed them data and expect to be excluded from any lawsuit that was brought against the BPO. So everybody in the chain has a responsibility to maintain TCPA compliance, follow the opting for a BPO. The question needs to be brought up early about TCPA and DNC compliance. Talk about the infrastructure that BPO is utilizing, whether that infrastructure could be construed as an ATDS, et cetera. So I think there's a large due diligence process that should go into choosing or reevaluating your existing BPO if you're doing any outbound dialing.
Thanks. Nick, do you have anything to add to that?
Yes, I mean, I totally agree with that. I would say that on both the BPO perspective and the seller perspective, you can allocate certain risks via contract, but those, through indemnification provisions and whatnot, but those indemnification provisions are a backup. I mean, so you get sued by a consumer or by a regulator, any of the entities can be held responsible, as Jeff said, and then you may try to get reimbursed for certain expenses or settlements or judgments through the other party, but if they can't pay, then you're stuck with it. But nonetheless, you probably do want to consider those types of provisions. Just don't rely on them as your sole protection.
Okay, so one of our attendees says that they do manual calls and are wondering if they have any TCPA or other state exposure. Brian, do you want to answer this?
Sure. So manual calls have restrictions if you're a telemarketer and you're calling into 5 states. They have additional restrictions against calling even via manually to a cell phone, so even without a dialer. So in, I think it's Texas, New Jersey, Arizona, Louisiana, and Wyoming, they all have a state kind of pseudo-wireless, almost do-not-call rule, unless you've got some sort of consent, depending on the state and what the state defines as their level of consent. So that's one area to kind of look at.
Okay, and Ryan, is there any way to scrub out professional litigators?
Yeah, we actually put out a product about a month ago that does just that, that identifies professional litigants based on their phone numbers. So we've got about 70,000 of them that we've got that we're continually adding to. I think we added about 2,500 numbers in a month last month. And so it's kind of an extra step, kind of next evolution in trying to, in our minds, try to level the playing field a little bit. Because a lot of these litigants seem to want to, they're opting in and they're trying to prompt response. So we found a way to extract a lot of the phone numbers from the cases and from some of the attorneys. So that's part of something that's available now.
Great, thank you. So it looks like we're running out of time. If you did send in a question we didn't get to it, we will make sure to follow up with you via email either later today or tomorrow. And we will be sending out this recording later this week as well, so make sure to share it with any coworkers that might also be interested in TCPA compliance. Also, make sure to sign up for our other webinar on HIPAA compliance. If interested, you can sign up at connectfirst.com/resources/webinars. Thank you so much for joining us today. Nick, Ryan, Jeff, thank you all for sharing this information on TCPA compliance, and we hope you all have a wonderful day.
All right, thanks everybody.
Thank you.
Thanks. Appreciate it.